So I received an email about an hour ago and I thought I'd do a quick short. In fact, I might do a lot more of these to give some general guidance if you subscribe to the channel. Not to be taken as advice, you understand, but someone suing a large company, won't say who, and they've obtained judgment by default against them for many thousands of pounds. That company is now applying with a new solicitor to have this set aside, judgment in default set aside, and it's coming to a hearing and they feel out of their depth and they've no idea what to do. So what does all of that mean and what would you do about it? Well, in short, if the other side doesn't respond to the claim form, then you will get judgment in default within 14 days, or after 14 days if they don't respond to the claim form. If they file an acknowledgement of service, then they get another 14 days, and if they still haven't filed a defence by then again you get judgment in default. That means you win the claim because they just haven't responded to it. But as is the case very often with these large companies, the claim gets buried or it gets sent to the wrong place, and it isn't put in front of the right people. And so there's all sorts of reasons why they may just honestly not have had the opportunity to respond to it. And so what very often happens is they then get a solicitor on the case who applies for the judgment in default to be set aside and that it should go to a proper hearing to hear all the evidence, etc. And of course, it depends on all the reasons for that. It's got to be a good reason, etc. But very often, the court will just set aside that judgment in default if they've got a good reason for that. And there's obviously tests involved in that as well. So I have done longer videos on this. I'll probably do some more longer videos on this. But if you're interested in these very quick guidance videos, do subscribe to the channel. So very often what we say in those situations is really you should accept and agree for the judgment to be set aside. That might save the costs of the hearing if it goes to a hearing, because if you refuse and it goes to a hearing, you may end up paying the costs of that hearing if the judge agrees to set it aside. Very often, though, the judge will just make no order as to costs, but that really does depend on the judge on the day. So there's some guidance. It depends what the reasons are for, but do subscribe to the channel if you want to hear more.